And
Britt.
thank you both for being here. I'd like to give you an opportunity to talk about your wife again. I heard what you said about her. I know what it means to be in a partnership. And I would hope that if my husband was asked, he'd have a long list of things that I am better at than him. But will you tell me a little bit about your wife and her accomplishments? And I'd love to hear it.
My wife is the most beautiful woman in the world.
Love it.
She is one of the most professionally accomplished women that I have ever met. First term.
Which for all of you know, the staff around here is where things really get done. So thank you.
And she worked for a Fortune 1 company.
Wow.
In the executive speech writing.
Sounds like an accomplished woman, both just throughout her life.
Thank you, Senator. I could not be prouder of my wife.
Well, I'm certainly proud to hear you talk about her as well. Thank you. I want to talk to both of you about something you've previously expressed, and that is originalist and textualist interpretation. I know that this is an ongoing debate. Is it the, same thing? Is it different? Is it distinct? Are they related? How does this work? I'd love to get your thoughts on that methodology and your views on kind of how those terms should be defined and then what role they will play for you on how you approach things before you on the bench. So we'll let you go ahead first, and then we'll go to Mr. Tung.
I think that they're best understood, originalism and textualism, as two sides of the same coin. As I understand it, it requires a jurist to look into the original public meaning of a text, whether it be a constitutional provision or a statute. And so you would seek to apply a law in the manner that a reasonable person would have understood it at the time that it was adopted when you view it in full context. And so that is the approach that I would seek to bring to the bench should I be confirmed in order to keep my decisions firmly grounded in the law.
So real quick, obviously Senator Lee asked Mr. Tung about this, but Article 1, Section 7 in legislative history. Give me your thoughts on that.
There are, of course, Senator Lee's question suggested there are different types of legislative history. Some drafting history is much more objective and useful to a court. But the question, as I recall, was directed to subjective statements of individual legislators.
He specifically mentioned floor speeches, et cetera.
And that, to me, is not particularly persuasive because, as previously alluded to, it did not go through the bicameralism and presentment requirements, and it goes more to a subjective intent rather than an objective meaning.
So, Mr. Tung, do you support originalist, textualist interpretation? And if so, if you can give me that quick definition and then how you arrived at that conclusion that would be the most appropriate methodology if, in fact, you believe that.
Thank you, Senator. So I do subscribe, Senator, to originalism and textualism. As Mr. Dunlap so articulately stated, originalism is a method of interpretation of the Constitution that looks to the original public meaning of the specific provision at issue. Textualism addresses the method of interpretation with respect to statutes, but both methods are aimed at the same thing. What did the words mean at the time that they were enacted or ratified? And I subscribe to that view because veering away from that view turns judges into policymakers. No longer are they grounded and anchored in the text, but rather they would be indulging in their own personal policy preferences, and I don't think that's the role of the judge.
Which you've said time and time again today, your personal preferences aren't what you're going to take to the bench. So thank you. I strongly believe the federal judiciary has a vital role in protecting religious liberty and freedom. I have been heartened by the Supreme Court's religious liberty jurisprudence in recent years and would like your thoughts regarding the role of the judiciary in defending religious freedoms for all Americans.
Senator, the Supreme Court plays a very important role in defending religious liberties. The First Amendment of our Constitution says it right there. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And the Supreme Court has faithfully interpreted that provision recently.
Thank you, and we'll in my remaining time.
I would agree. The the courts have the responsibility to apply each of the amendments to the Bill of Rights. The First Amendment and the free exercise of religion and the Establishment Clause have been observed to be first freedoms. Those are binding upon the court and should be equally applied for all Americans.
Well, thank you both for your willingness to serve. You're incredibly accomplished and look forward to getting you on the bench.